though when the data relevant to US civil litigation are located in an EEA member state and contain personal information. There are serious conflicts between the US eDiscovery obligations and the EEA Data Protection obligations. I have the honor to introduce you to a very distinguished panel of experts who will elaborate on these issues and propose some practical solutions. And they will introduce themselves, starting with Amor.
I'm to Monique's right. My name's Amor. I've already been introduced, so I will give it to Jim.
Thanks. My name is James Daly, and I'm an attorney, a United States attorney, and also a certified information and privacy professional. I have a boutique firm that focuses on eDiscovery, records management, and data privacy issues.
My name is Monique. I'm a German lawyer. I'm a partner and head of the European Data Protection practice of the law firm from Baden-Bellis. We are based here in Brussels. I'm also a certified international privacy professional, and I also have a qualification as a data protection officer in Germany.
My name is Romain Robert. I'm working as a legal advisor at Belgian DPA, the Privacy Commission.
My name is Natascha Gerlach. I'm a German attorney at Cleary Gottlieb here in Brussels, and I currently head up the eDiscovery department of the Brussels office.
Monique, why do I feel I'm at a dress rehearsal? Or possibly even worse, an audition. My name is Stephen Whittaker. I'm a judge in the United Kingdom. The main reason I'm talking about this subject is that I'm the central authority of the Hague Convention in our jurisdiction, and so I have to manage quite a lot of requests for the disclosure of documentation from our jurisdiction, particularly to the United States.
My name is Nigel Murray. I'm Managing Director of Huron, based in London. We provide services throughout Europe, primarily on cross-border movement of data and documentation for litigation and regulatory matters.
Okay, thank you. Since the issues involved here tend to be very complex, I thought that it might be a good idea to work with a mock hypothetical case. So we have this following case. Merck is a global pharmaceutical company with headquarters in Belgium and many subsidiaries in the US, Germany, France, and the UK. Jim Ill and Jack Sick are class representatives on behalf of users of the drug Viagra, manufactured by Merck, Inc. in the US. The class suffered serious side effects after using that drug. The side effects range from heart attacks to strokes and aneurysms. The plaintiffs claim that Merck did not warn users of those side effects, even though Merck knew about the risks. They are suing Merck in the Southern District of New York for many millions in damages. The plaintiffs have made a request for productions of all relevant data by Merck, Inc. You are the general counsel for Merck in the US. What do you do regarding personal data coming from the Belgian, German, French, and UK branches? So, my question to Stephen, who is the expert in the Hague Convention, is: would you send separate letters, if you were the general counsel, would you send separate letters of request to the judicial authorities of Belgium, Germany, France, and the UK, as per the Hague Convention on the taking of evidence abroad, and what would be the pros and cons of going that way?
Okay, Monique, the first point I think that needs to be made is I certainly wouldn't be sending it to Belgium because, curiously, although Belgium signed up and acceded to a number of Hague conventions, including the Convention on Service and lots of other things, it's never acceded to the Convention on the Taking of Evidence. So Hague requests to Belgium would not be a particularly good idea. Whether there's a bilateral from back in the 20s or something of that sort with the States, I've not been able to have time to find out. The importance, I mean, why do we ask why? You might want to make a request on the Hague Convention. The answer to that is if you look at what the Article 29 Working Party have said about the Hague Convention. Just to explain to those who have not heard of the Article 29 Working Party, when the original Data Directive 1995 was promulgated, under Article 29 it set up a working party to monitor the progress of the directive and to make reports, and there have been hundreds over the years. Report 158 rather in particular is an important one, in which it's been stressed by the working party that in terms of justification of transfer, the use of the Hague Convention is seen as a valid justification. So far as transfer is concerned, an application under the Hague and getting an order from a jurisdiction within the EU which is able to make such an order, at least relieves you of having to look at the other criteria for justifying transfer of data. But I think the thing one's got to be very careful about is it doesn't exempt you from complying with the obligations in respect of processing in the first place, that is collecting the data and processing it anyway. The collection itself is processing, but collecting it in any way in order to be able to send it out of the EU. And that's one of the reasons why it's considered to be an important subsidiary way of being able to get hold of data. So the pros are less problem with transfer, maybe in some respects, for example in France, less problems with blocking statutes because you have to go through the court. If you get a court order in France allowing the information to be transferred out, one of the things that the court in France will look at will be the terms of the French blocking statute, and presumably if the court in France considers that the information doesn't contravene that, you'll be protected from being shoved in the slammer in Paris for having contravened French law, which I'm afraid is now a practical possibility. Those really are the pros, but there are a number of cons. And I think one of the reasons why in the US it's not used, the convention, as much as it might be, although I would say that that's largely the fault of the way the US lawyers attempt to use it. Apologies to those US lawyers who are here. There are some cons, and one of them is that you cannot get disclosure in the same wide, broad sense that you can under a Rule 34 request in the federal court in the States or under the state rules. You cannot have what we would call in England general disclosure. You cannot have an order in one of the Hague Convention EU countries, because unlike Belgium, there are a number of countries that aren't signed up to it, which says the witness must just produce everything it has in relation to a particular topic in that unspecified sort of way. The reason for that is Article 23 of the Convention. Article 23 gave all the nations that acceded to the Convention when they accepted it to specify that they would not allow it to be used for what's called, in inverted commas, pre-trial discovery. And pre-trial discovery doesn't just mean something that's asked for well before a trial rather than just before a trial. What it means is it's getting at the concept of pre-trial discovery as it's intended to be in the common law countries, particularly in the US, who I'm sorry to say, when the convention was originally drafted, were seen as major offenders in this respect. So you can't have, and I don't think there is an EU country signed up with it that hasn't had a derogation under Article 23, you can't have general disclosure. What you can have, though, is the disclosure of, by some sort of evidence, the witness is likely to have or has in their possession. And when I say specified documents, I don't mean just individual pieces of paper. It can be a file, it can be a compendium of documents. But they have to be specific. There has to be much greater specificity than in a normal disclosure request as in the US courts. So that's the main con. You can't simply bolt on to your federal or state disclosure exercise another request sent to another person outside. You can't depose the witness as to documents, for example, or indeed as to oral evidence. Now that's one of the major cons. The other con, I think, which is seen as a major problem in the US is the amount of time that it can take to put a request through. I don't think that that would be a problem if, when sending the request, the US courts actually took a little bit of notice of what I've just said. Typically, in my position as the central authority, I receive at least one request from the US a week, sometimes more. And I can guarantee that 90% of them, the schedule at the back of the request signed by the letter request signed by the American judge, will have a document request on it which will be identical to the sort of document request that will be used in the actual litigation under the federal or the state rules. It will be all this, all that, all the other, and the kitchen sink. And we can't do that. So the requests tend to get knocked back, or sometimes the order will get served on the witness, and the witness will simply refuse to undergo the exercise. That will be found by the English court or the French court or whatever to be proper. And of course, in our jurisdiction, and no doubt in France and Germany, although the Germans, I think, have a much better system as far as costs are concerned than we do in the UK, an adverse costs order will remain. So whereas, of course, the American requesting party is used in the States to no cost shifting unless there's a sanction, and they suddenly find they get it wrong under the Hague Convention, and they get whacked with a huge bill of costs. Those are the cons. But there is an answer to that, and that is that you can make a request much more specific if you put a lot of effort into making sure you make the request early, you're well prepared, and you make it specific for the documents you really do need that you think the witness has in Europe. It can go a lot faster. Recently, for example, I had a request from the Southern District of New York. The judge just happened to be Judge Andrew Peck, who sat on many panels with me and listened to me giving exactly this lecture. And he's learned that there's no point in letting the parties before him send a general request. He makes them specify the documents that they want. And so far it's worked extremely well. We've been able to deal with that type of request within weeks. If the Hague Convention isn't used, the alternatives are effectively for the party in our jurisdiction to be asked voluntarily to produce the documents. Because the other con, which I haven't mentioned, that's the thing that's appropriate and useful about the Hague Convention, is that we, when activating it, can compel a witness to produce the documents. And that's the major advantage, I think, for any lawyer in a foreign jurisdiction using the Hague Convention. Compulsion can be applied. And so if you specify the documents carefully enough, you can compel the witness to bring them out. So the general answer to your question, Monique, would be yes, I would, and I would attempt to make sure I did it properly, so that I would get the result I wanted out of the EU court that I was asking the order for, that I would get compulsion if I needed it, and I would at least overcome the problems of justifying transfer out of the jurisdiction. But I'd do that on the basis that I was well prepared to justify the actual processing of the documents in the jurisdiction.
Thank you, Stephen. But, you know, I'm thinking Burke has terabytes of information related to the drug Viagra. And so from what you just explained, it doesn't seem like the Hague Convention authorities would grant permission for this discovery of such a vast amount of,
No.
of data, right?
Simply not.
So
Because
we have to look elsewhere for another solution. And I would ask Monica what she would suggest as far as Germany or France, because you mentioned that you know how it goes over there. So what are the other solutions?
Yeah, and coming back to your question whether the Hague Convention would be a venue to go for Germany. But for Germany not, because as you already mentioned, there's this famous Article 23 in the Hague Convention where signatories can make reservations whether or not they want to comply with pre-trial discovery requests, and Germany has clearly stated they won't. So any requests under the Hague Convention for the disclosure of documents for pre-trial discovery requests will never be accepted by courts in Germany. So definitely for Germany that's not the way to go. For France, I would mention it, but there is basically, they made also a reservation, but they are in principle accepting this route. But they are clearly saying that these disclosure requests must be limited, must be focused on a limited number of documents, so that we have again your problem, and must have a direct connection with the subject matter of dispute. So again, two qualifications, but then French courts, French judges will look at and may ask that, you know, I mean, may say that this request is too general, too vague, and that it would need to be more tailored. And on the other hand, for France, I mean, not being a French lawyer, so, you know, don't take it for granted what I'm saying, but what I understand under French law is, on the other hand, you definitely should try to go via the Hague Convention in France, because the French Data Protection Authority has also clearly said that any processing of data in France and any transfers abroad they must respect the Hague Convention. So if they don't respect the Hague Convention, they also consider this to infringe the French data protection law. And on top of it, there's also the blocking statute, which you have mentioned, and which also basically says that, yeah, whenever you disclose documents, you have to follow the Hague Convention. So for France, I would say yes, try this route. For Germany, no, it doesn't make any sense.
Okay, so you would have to process the data based on the EU data protection rules. You really wouldn't have a chance to do it through the convention. So this is the only other solution.
Yeah, I mean, these are two different things. One thing is you have to, in France, go through the Hague Convention, and on top of it, you have to comply with the French data protection law, which is yet a different set of rules. And there you need to look and see whether you can justify the processing under the French data protection law, and also the same in Germany. You have to see whether you can justify it under German data protection law. And the second thing, as you said, the same analysis you have to do for the data transfer.
So how would you justify it under German and French, and also probably Belgian data protection law?
Yeah. I mean, as you all know, if you want to process personal data, we have all the directives, so there are certain grounds that are listed on which you may want to base yourselves. The Article 29 Working Party, which you've already mentioned, they've also issued a paper where they analyze different legal grounds on which you may be able to base the processing of your personal data. The main legal ground that you can use is the so-called legitimate interest criterion, which basically says if the controller has a legitimate interest in processing the data, he can do so, but there needs to be a balancing test. His legitimate interest needs to be balanced against the interest of the individuals whose personal data are being processed, and then you have to see which side of the balance outweighs the other one. And so, yeah, it's this balancing test, and of course, it's very complicated to apply it, and you need to do this on an individual case-by-case basis.
What about consent? Isn't that one of the legal bases that I mentioned?
Yeah, consent is a little bit tricky already under the present law, because it's been interpreted rather restrictively by data protection authorities. Especially, I mean, again, it depends now on whose personal data is transferred. If it's customers' data, there may be an issue in that, you may have difficulties in contacting all these people. Then there's the problem, if it's massive data, as you say, there may be a problem of getting hold of all the individuals and obtaining all these individuals' consent. And then there's the additional problem of employee data. So if you needed to transfer employee data, the Article 29 working party, and that's also the main opinion of most of the national data protection authorities in Europe, is it's sometimes very difficult to base yourself on consent of employees because they are in a subordinate relationship vis-à-vis their employer. But consent is defined as something which is freely given. You need to have a genuine choice of whether to say yes or no. And if you don't have this genuine choice, then it's not really given, and then it's not valid consent. And then, but again, depending on the context, there may be cases, where employees can consent to this, but you have to look on a case-by-case basis.
Thank you. And I have a question for Romain. This case concerns health issues because people have been hurt and they have to prove that. So I would ask you, are there any special requirements for sensitive data, which health issues are part of?
Yeah, first of all, I'd like to mention that I heard from a practitioner in Belgium some solicitation from Belgian judges on the basis of the old Den Haag Convention. I don't know if you heard about it.
The 1905
Yeah, or as an international habit of Jew, accepted by Belgian judges when they were introduced by the US. Even if the US didn't sign the first one. So it's just an information that I heard. So Belgium might be able to invoke the Hague Convention, even if it was not ratified in Belgian law. So even though it's not very clear whether or not you can use it to obtain information in Belgium, and the other question is, of course, to know whether or not we are confronted with health data or sensitive data. Of course, obviously, health data are sensitive ones. They are protected as such by the directive and Belgian law, which is implementing it. Obviously, the EU regulation is also addressing this issue, and you have to go through the Working Party 29 document, which is addressing this issue, since sensitive data are supposed to be protected a bit more than regular data regarding all the context of the transfer. So it will also have to be examined whether or not these health data are anonymized or not, because most of the time the pharmaceutical companies are not processing non-anonymized data. So if they are, for example, it wouldn't be a problem to transfer it, because will no longer be considered as personal data. If they are, it still could be transferred with the condition to respect some of the conditions laid down by national law. Belgium, for example, this transfer has to be monitored by a doctor or professional specialized in medicine. We had also to make sure to put extra security measures to secure the transfer.
Okay, thank you. And then I have a question of Natasha. Since you have a lot of practical experience in the area, what other measures can one take to ensure the proportionality test?
I think it's generally a common sense approach, and as was mentioned before, that the very broad requests that we're used to in the US are simply not acceptable here. So I think the idea is to be very specific when you start to think about what data may be collected, so you cannot go on a fishing expedition and simply take everything and then look through everything and see if you find something. So at the point of collection of data, you already have to be extremely specific as to whose data you wish to see, what time period you wish to see it for, and potentially, restrict it also in terms of which data do you have to collect emails? Is it sufficient to collect work documents that are not personal data? So that's one of the steps. So you collect data, but you restrict the amount of data that you can that you do collect. Once you have the data in hand, you can then further restrict data that may have to be transferred on by applying search terms. For instance, you duplicate data, you pull out duplicates and so forth, and then whatever is left, you then are very specific in what you're searching for, what you're looking for in the data set. So you agree on a set of search terms that should be used, for instance, which minimizes the amount of data that gets placed even in front of reviewers, to then look through and look for the evidence that you're potentially looking for in your case. And once you have achieved, a subset of documents that you find, or data that you find is responsive to the request at hand, you can further limit the amount of personal data that gets transferred by anonymizing it. You can apply redactions and take out personal information on documents, for instance, which happens frequently, where there is a mix of documents. You have part of the document that is relevant and another part where somebody applies, oh, and by the way, I have an appointment with my doctor also at 5 o'clock to, for consultation X. That obviously is sensitive data, and it has nothing to do with the case, so you want to take that out. Also credit card numbers, social security numbers, things like that. As far as they do not pertain to your request at hand, you should ensure that those are taken out, that they are redacted in a fashion that the redactions cannot be looked under. So you need to make certain those are branded onto the pages, and the data is then that subset gets transferred. It will be less personal data on the smallest amount possible.
Okay, thank you, Natasha. And now I have questions for the Americans here. How are the suggestions? What are the suggestions of the just published Sedona Conference International Rules regarding this issue?
Well, I'll let Jim handle the Sedona issue. Let me address a couple of things from a practical standpoint. You have in your hypothetical that we are the general counsel for the firms that company work, and our companies are our affiliates are in Belgium, Germany, France, and the UK. Right? So the way this would really work from a practical standpoint is the plaintiffs would demand through discovery the information that we have support. We might say that we're obligated under one of the laws of one of these countries to use the Hague Convention, but we ourselves would not use the Hague Convention because we own the data, so we don't have the need to apply to the Hague to get access to our data. The court would use, and whether or not the court would obligate us to produce the information in the United States. So, and this is what I think Jim will cover on the Sedona Conference, we've come up with a process where we think we mitigate a lot of those issues. But the bottom line is that the data is ours, and so we would not ourselves be applying for the Hague Convention to get the information. With regard to the Hague Convention, from a practical standpoint, again, usually that only comes into play in the United States if the party that has the information you're trying to obtain is not within the jurisdiction of the U.S. court, and then you would go and apply through the Hague. If on the other hand, the party is in the United States, as I said, it goes back to the process I said before, you may try to defend on the basis that the other side should go through the Hague, and then the court will make a decision whether they're obligated to do so or not. But, so again, and as Master Whitaker pointed out, one of the big defenses against using the Hague is the time and the expense of using the Hague. And to use Master Whitaker's term of knocked back, that happens very, very frequently, perhaps not in the UK because we have such an But in other countries, you will send in your request for the Hague, you'll follow the letter of repertories, you do everything according to the Hague Convention. It takes about a year, and then somebody in an office in whatever country you're in looks at it, and before they assign it out to a judge to implement it, they'll kick it back. And then there'll be some issues and they'll have to be solved, and that takes more time. And then finally it goes to a judge, and then that judge may kick it back as well. So the long and short of it is the U.S. experience using the Hague is not very simple. It's very cumbersome. It tends to take a long period of time, and it tends to be very expensive. And so judges are reluctant to require parties to go through the Hague unless there's no other alternative, in which case they usually do. So those are the points I want to make. I'll pass it on to Jim.
So the approach that the recently published Sedona Principles takes is to try to harmonize these competing considerations of U.S.-based discovery and, on the one hand, and data protection regulations as well as blocking statutes on the other. There are two principal ways in which it does this. One is it tries to expand or extend that level of protection for EU personal data as part of a transfer, particularly in the context of litigation or regulatory investigations. And it does that in two ways. One is it really stresses the need to have protective orders issued by courts in the United States that, in effect, gives some teeth to the principal rights of data subjects whose personal data might be at issue in the transfer. And second, it establishes a recommended safeguarding process and transfer protocol. So it tries to put some procedures around the actual transfer for this purpose so that that bubble of protection of the personal data can be extended across the Atlantic to the United States jurisdictions. Now, it's not perfect, but there is no perfect solution currently. So it's really a way to try to mitigate risk and hopefully harmonize as much as possible those two competing forces. Now, I think it's important to note that in this regard, the sensitivity to the personal nature of the data, whether it's personal data or personal sensitive data, would be incorporated in the court's order and would be part of the safeguarding process and transfer protocol. So what these two things try to do is they try as best as possible within the U.S. context to incorporate principles of data minimization, including the anonymization that Natasha talked about. They try to incorporate principles of accountability. They try to incorporate principles of privacy by design with respect to specific data security safeguards as part of those orders and protocols. So it tries as best it can to incorporate those as well as the principle of proportionality in a way that I think heretofore has not been done quite as uniformly in the United States. So I think there is a lot of hope to be had between the new regulation that has just been announced, calling for uniformity among EU member states, and then a uniform approach in the United States, if adopted, that would utilize court orders as well as a specific validated process and protocol. Now, in practice, what I have been working with my clients on for a number of years, with clients in France, Germany, elsewhere, is a process of trying to do in-country culling using recognized search and retrieval mechanisms, recognized deduplication mechanisms, giving data subjects the right as part of a collection effort to segregate out themselves what they believe to be personal sensitive data and personal data having absolutely nothing to do with the actual need. Combining notice, very specific notice, with any kind of and consent with any kind of a legal hold process that's involved. Because obviously just issuing a legal hold and asking that it be complied with itself is technically processing under the EU directive. So combining that clear consent and notice of the intended purpose of why the information needs to be preserved is an important aspect of that. And trying to get validation of those processes in advance by speaking with the local data protection authorities or works councils, I think has been heretofore a best practice that these principles are trying to make more uniform.
Okay, thank you, Jean. I have a question for Amor. How are these suggestions of the Sedona principles similar to the Working Party 158 opinion? And if they differ in what aspects?
That's a good question. I will say that the Article 29 Working Party's thoughts on the cross-border discovery issue and transfer of data was very much taken into consideration by the Sedona Conference, Working Group 6, particularly with regard to Working Paper 158, which is where the Article 29 Working Party gave so much information. There's also a subsequent Canova paper that came out by the French data protection authorities that was also used to develop the protocol. And the protocol, as Jim kind of spelled out, really has two parts to it. The first part is 6 principles that we lay out, essentially as policies that lawyers and judges and data protection authorities should incorporate into their processes for the legitimization of the data and ultimately the transfer of the data. And those are spelled out in the paper that was handed out. And if anybody doesn't have one, there's some here in front. We can pass them back. But if you read through those 6 principles, you'll see that what we try to do is distill the principles from the Article 29 Working Paper 158 and the Canova paper and put those principles in here. So, for example, recognizing the rights of the citizens, the non-U.S. citizens, to individual data privacy. There's recognition that the parties in the U.S. have an obligation to process the data in a way that maximizes the security of the data as well as the individual rights of the citizens. As Jim pointed out, we advocate that there be a filtering system which leaves that data that's not necessary here. And the filtering system, if I go through it for a quick minute, I won't go through all of it, but one of the things that's important to understand is that not all data that's requested in U.S. litigation is subject to the Data Protection Directive. So one of the very first things to do is separate that data that is not personal data, and that can be dealt with completely separately. It can be sent over and done with whatever is necessary. It tends to be economic data, financial data, straight business data, information of that nature. With regard to information that does fall within the definition of personal data, we then advocate a filtering system, which it starts with doing the processing here in country, in the EU, rather than doing at least the initial process in the U.S., taking steps to identify the data, redact the data if it's not relevant, trying through the protective order process that Jim was speaking about, trying to get the court to agree to narrow the definition of what's relevant so that we can avoid bringing over a lot of information. So these requests that Master Whitaker talked about in terms of any and all data that's related to this subject, we would ask the court through the protective order process to narrow that down so that we're we would ask the court to impose on the parties in the United States the obligation to protect that data as if it were here in Europe, and would provide the traditional sort of protections that would go with that. And the nice thing I'd like to report is that some very important judges, including Judge Shinlin, who's very, very active in the eDiscovery space, have agreed with that process, and a lot of their thoughts have gone into this paper as well. So that's, the 6 principles are very important. The 3-pronged approach, which is a way we would ask the court to impose those restrictions on the parties, as well as then the data holder, the data controller itself, taking all of the meaningful steps to protect the data. So to answer your question, that's a really long way of saying we at the Sedona Conference very much were influenced by the working party, our working party's efforts, and we try to incorporate as many of their suggestions as we can.
Thank you very much, Mark. And so I have a follow-up question. Assuming that the lawyers follow your step-by-step protocol, I read this paper, and at the end you have a very practical protocol to follow step by step. So, and you bring the case in front of the judge, but you couldn't get all the necessary papers because you were restricted. So how would, except for Judge Shan, how would the other district judges react according to your experience? Because I know there are a lot of variations within the U.S. As far as this is concerned.
You know, it's another interesting question. I learned a lot at a conference that actually Jim Daly was moderating at the Georgetown conference, which is a very famous and important meeting that's once a year in the United States. And Jim's panel, which I believe Chris was on as well, if I remember correctly, addressed this issue of the cross-border transfer of, you were on that one, Chris?
Not this year, last year.
You were on it. Okay, a lot of people on it. Anyways, the point was there was a number of judges in the audience, and the important thing that came out of the conference from my standpoint is the U.S. judges, both federal judges and state judges, came to the group afterwards and said, we did not understand the importance of this issue. Nobody had ever flagged this for us. And I think, by the way, that's an important learning, too, from the cases. If you read the cases that apply the gross facial balancing test as to whether or not to apply the foreign law or the U.S. law, one of the things that sort of strikes you is the poor approach that a lot of lawyers took to ask the court to respect the data protection laws of the non-U.S. country. And in the cases where the advocates succeeded in having the court understand the data protection laws, which was a couple of cases I talked about before, the Volkswagen case out of Texas and the credit card case, the Visa MasterCard case out of the 2nd District in New York. In those cases, the advocates did an excellent job, even bringing in representatives from the European country, sometimes the declaration from the Data Protection Authority. So a lot of what we're learning in this is that judges are not adverse at all to this process. What we're learning is they don't know about this process. And once the smart people who understand the Sedona Conference principles apply these in a practical setting and put these in front of the judges, I think we're going to start seeing a number of rulings that support the respect for the European data protection laws.
Thank you, Amor. Would you say it's fair to say that we need to educate the American judges?
Yes. That's all I want to say.
All right, so I have a question now for Romain, who represents the other party. How do you think the data protection authorities would react to parties who abide by the Sedona conference principles and try their best? You know, they can't completely abide by European data protection rules, but they try their best in light of their obligation to produce some documents.
Good question. Of course, it won't be easy to answer from a European point of view. Maybe from a Belgian law point of view, as you might know, currently the Belgian DPA doesn't have any sanctioning powers or blocking powers, but it might change with the new regulation, as you have seen. So on top of the sanctioning powers, blocking powers that also been granted to the DPA. So that might be a solution for DPA to block a transfer that would not be compliant with the future regulations, of course, because the current state it wouldn't be possible. And although I just speaking for the future, of course. But
yes, I was going to ask that question. The follow-up questions: how will the new regulation change the cross-border e-discovery?
One thing that can, I'm sure, that can be inferred from the answers from the different panelists, that even with the directive, the data protection directive, you can see that different member state legislation are not fully harmonized and uniform, so you won't have the same answers from all the lawyers that you will be taken and advised from in every member state's country. So, for example, in Belgium, on top of the data protection legislation, we will have the employment law and the telecommunication law protecting emails, for example, and prohibiting the employers to transfer or just to store or take knowledge of the emails on the employee. So it would also might be considered as a blocking status, but it's not the same as the blocking status as in France, for example. Those restrictions should more or less be abundant in the future regulation. However, there is still space for specific regulation, for example, in the employment area. So I'm not sure the future regulation will solve the problem. The thing is that on top of the blocking powers, there is the documentation obligation that I'm sure that will help the companies to draft and to have proper documentation about all the processings of the data that they are dealing with, to have a good idea of where are the data, what can be considered as sensitive data, relevant data or non-relevant for litigation in the future, for example, for eDiscovery. So I'm pretty sure that this documentation obligation will force the industry and the companies to think a little bit more proactively with the idea of a potential eDiscovery procedure.
Okay, thank you.
Yeah, one quick response. We try to take that into consideration, and one of the things we're very excited about is at the end, it's Appendix C to Principles, is a document we call the Stellar Conference Cross-Border Data Safeguarding Process and Transfer Protocol. And what it does is it spells out in a number of paragraphs all of the various steps that a company might take to legitimize the processing and ultimately the transfer of the data. And it strongly urges companies to keep track of the steps that were taken and how they were taken and who took them, so that by the time you are ready to transfer or you have transferred, you have essentially what's the word I'm looking for, a follow the rule kind of list, that if you do all these things, or at least try to do all these things, you would hopefully satisfy the European data protection authorities as well as the U.S. courts, because you demonstrate to the U.S. courts that you've also taken all these safeguards.
Thank you, Mark. So we have talked about how to process the data in light of the data protection rules, and we have minimized them, we have anonymized them, we have pseudonymized them, and we have duplicated them, but now we have to transfer them to the US. It's considered a separate step. So I have a question for Nigel. I haven't heard you speak yet, so Nigel, tell us a little bit about the different ways of transferring data from the EU, and what do you think are the preferable ways?
Thank you, Monique. I'd just like to cover some of the points that we've just covered, as well as a preamble to that. One of the fundamental challenges in this business is the different definitions of what is going to be relevant, what is proportionate. And I say to American colleagues, well, when they were translating English into American, they forgot the word proportionality. And what is deemed to be proportionate, whether it's collection, whether it's review, or whether it's transfer, in American lawyers' mind or American judges' mind, is not necessarily what we in Europe would consider as proportionate. Now to transfer, Natasha covered the basic principles of what one wants to do. Try to keep the amount of data that is transferred to the absolute minimum, to those documents that are going to be directly relevant to that matter, through the filtering process, through the review process. The review process, for those who aren't lawyers, is a lawyer looking at a document, deeming that document to be relevant to the case or the piece of litigation or the regulatory inquiry or not. So the documents that are relevant. And then, if needs be, redacting means blanking out the personal information about that is contained within those documents. And then transferring according to under a protective order. And I believe within the Sedona Pact there is a sample of something more correct if I'm wrong, of such an agreement. Protective order is where a judge imposes on the parties confidentiality obligations. Those confidentiality obligations are you will not pass those documents on to anyone else. Now, that, to my mind, is all well and good. However, the aim of transferring data to, we're talking about the United States primarily, but we'll continue with that, the United States, is that that data will be used, ultimately, if it's for litigation, in court. And I'd like the views of our American colleagues as to, even if data is transferred under protected protocol, some of those documents, at the end of the day, are going to end up in the public domain, and how that paradigm has been squared away.
Just a few comments in response. I'll speak first to processing, because I think I would take a bit of issue with the statement that there isn't a strong policy and rule framework today for minimizing the processing of personal data, whether it be in the United States or whether it be in the EU being brought to the United States. I think the new federal eDiscovery rules that have been in effect since December 1 of 2006 have armed judges, at least at the federal level, and in those states that follow the federal rules at the state level, with the tools they need to be more proportionate with what they're asking companies to collect and retain, number one. And to the extent that that can be minimized, that decreases the risk of unwarranted data transfers as well. I think those rules have also given the judges in the United States the tools to prohibit with strong sanctions the unauthorized onward transfer of personal data for a use that has not been clearly articulated in a consent signed by the data subjects, and which has not clearly been articulated to the local data protection authorities in the countries from whom that personal data has been obtained. And that's exactly what these principles and framework try to do. They try to make more uniform what has heretofore been an ad hoc process that tries to, again, build in a level of accountability and proportionality and data minimization consistent with a lot of the themes in the Working Party document 158 and in the Canil Deliberation. So I think that would be my response. More?
I guess I would just add this, Nigel. The U.S. courts are not strangers to protecting confidential information. Protective orders have been around for years. In fact, there is a rule in the federal rules, and most of the states have adopted it, that prohibits certain personal information showing up in a public filing with the court, like social security numbers, license, that sort of thing. So the courts are very much attuned to it. What does ultimately happen is, even if the judge enters a protective order like the one that we've used here as a model, at some point in time, when the case goes to trial, there is the possibility that some documents that have personal information may be made available to the public. And the rationale is that there's another competing rule that says that certain information at trials the trials in America are open to the public, and information has to be made available to the public, et cetera, et cetera. And the press is one of the presses that pretty hard. But even a judge would say, Judge, I know we're using this document in trial, but it has this lady's medical record in it, and it has this particular information, and I don't want this to be part of the public record. And the judge will, in most cases, redact that information, so long as it's not vitally relevant to whatever's going on in litigation. So again, there is some possibility that some information would get out in the public, notwithstanding these orders, but at that point it would be extremely minimal, particularly if the judge and the attorneys are doing their job correctly.
Yes, in most cases that's been my experience in over 30 years of practicing law in the United States as well. And I think the only exception to those cases where a judge would not is where the party themselves have put their personal data at issue by saying, I have personally been injured, and here are my medical bills, and here are my disabilities, and I want compensation for that injury. That's where it's for the data subject's advantage, because they are the moving party. One other thought that I think might be helpful here, and that is, I think in Working Party Document 158 and a number of other writings that I've seen, there has been a bit of confusion as to what we call document preservation or document retention in the context of litigation and regulatory investigation obligations. And I want to state clearly that in the United States, it is not the mere possibility of litigation or investigation that triggers that obligation. It is not the mere possibility. It is not the chance that there might be some kind of controversy. It has to be more than probable. There has to be imminent litigation. It has to be reasonably anticipated. That is the standard by which the judges hold both U.S. and non-U.S. parties that are subject to U.S. jurisdiction. And I see so often this image of the U.S. still being considered kind of the Wild West in terms of preservation on the one hand and production on the other. And I'm here to tell you that is not my experience as to how it works in practice.
Jim, can I just ask a question about that? I think one of the, seen from the perspective of this side of the Atlantic, I think what the working party were getting at there was the feeling that whereas the data protection rule effectively here is you hold the data as long as it's necessary for the purpose for which it was created, it should effectively be destroyed, and we're getting into rights to be forgotten and all that sort of thing in that respect. But I think the fear that there is here is it's not so much that American potential litigants keep material because there's a possibility of litigation. It's just that they keep material. In other words, they just keep everything for a very long time without any regard to whether it's necessary or not. And I think that's what the working party in that respect were getting at, not some expanded and I think wrong-headed, as you say, view as to what the American rule of law on preservation is, but that American companies don't operate the same data protection principle in that respect as EU companies.
Well, that is a fair point and a fair critique. I think that culture is changing a bit, however, as well. Perhaps not so much because of philosophical reasons or the idealistic notion of data protection, but for economic reasons. I think that we are well beyond the time in the United States where companies will just pack rat electronic and print information away without a thought as to what that means for cost and risk going forward. And I think it's been a strategic inflection point for the entire world to see what has happened in terms of the proliferation of electronic data and massive replication of it without an eye toward proper management of that information. So I think we're making headway there, and we're aligned with the EU and the rest of the world in trying to move in that way. I did, however, understand WP 158, though, to be addressing the issue of legal holds in that context. And where it is raised in that context, it does make important that we understand what that standard is. It's not potential litigation. It's not possible litigation. It's not just in case. It's where it's indeed more than probable.
Master Whitaker, I just want to point out to you our principle number 6, which is data controllers should retain personal data only as long as necessary to satisfy legal or business needs. And then it goes on to say that obviously if it's relevant to the litigation, then it has to be retained under U.S. law. But the rationale for putting that in there was twofold, and there was quite a bit of discussion on this. The first basis was because we are understanding and cognizant of the right to be forgotten, and I think it's also starting to take some roots in the United States. But the other part of it is we're trying to help parties get out of the quagmire of destroying data that they don't believe is any longer necessary for the litigation or reasonably anticipated litigation, only to be second-guessed and somebody says you should have kept that. So the data controllers say, well, wait a minute, I have an obligation under EU law to make that go away, and now you're punishing me because I made it go away. And what we're trying to do in principle number 6 is to raise that issue to the consciousness of the judges so that they recognize that sometimes data that may ultimately someday prove relevant to litigation may have a very good basis and based on good faith and rational thinking, proportionality, for example, it was gotten rid of. So that principle 6 is intended both to recognize the European concern as well as to provide some defensibility for the conduct.
I think we heard now a lot about the US perspective, but maybe coming back to your question, what do we do with the transfers from a European perspective? And maybe this discussion is also a bit significant of, the different ideas that the US, they are very vocal in this, and the Europeans are trying to make their position understood by people. So, coming back to the question, how do you justify a transfer under data protection law? Again, this was already mentioned several times. The Article 39 Working Party has expressed its opinion in this opinion, and they basically say, well, there are different legal bases, and it depends again whether it's a massive transfer of data or whether it's more single, more limited transfers of data. If it's a more limited transfer of data, then you all know about this possibility, Article 26D, which basically allows you to transfer data if it's for the defense establishment of a legal claim. But again, there is this reservation by the Article 29 working party that it shouldn't be a massive transfer of data. So coming back to your case scenario, that provision would probably not help us. And then if there are massive transfers of data, what the working party basically suggests is that you should have recourse to other safeguards, which are either the safe harbor regime, binding corporate rules, or data transfer agreements. And I mean, all these different instruments, I'm not going to go into detail, have their pros and cons. But the major issue with those is that they do not really foresee or provide for the possibility of onward transfer, or they do provide for this possibility, but then again subject to yet additional restrictions. And in most cases it will be very difficult for restrictions on their opponents or on the courts or to whomever they have to onward transfer this data. So there are several complications there. And then to add to the problems, because you had asked me to look a little bit from the German perspective and the French perspective, I mean, they basically follow what the Article 29 working party says, but in Germany particularly there's quite some discussion to what extent you can really apply this statutory derogation transfer is necessary for the defense of a legal claim. There is some discussion in literature whether this clause can actually be applied or relied on in view of Germany's reservation in the Hague Convention, so which I mentioned earlier. So Germany made this reservation in the Hague Convention. We will not comply with disclosure requests from US courts, for instance. And so some people argue in order to apply this, it's necessary to defend a legal claim. You have to interpret this necessity criterion in the light of this reservation for the Hague Convention, and you have to come to the conclusion it cannot be considered to be necessary if Germany made a reservation. Very complex considerations. There's another problem with this legal claims provision in Germany. As you all know, the directive is translated into the languages of all the 27 member states, and each of these language versions is equally applicable. And the problem is there are differences in the language versions of the directive. The English version is not really identical to the German version. In the German version, it says it needs to be necessary for the defense of a legal claim in court or before court or in court proceedings. And there is some discussion in Germany, and this has been transposed into the German law. And there's some discussion to what extent or what this means for pre-trial discovery. And there are certain people who take the view that pre-trial discovery is not court proceedings yet, and therefore you cannot rely on this provision. A very particular German issue, which might be solved with a new regulation, but also the regulation will be translated into 27 different languages or whatever, how many languages we have. So maybe this problem doesn't go away, and it depends on the quality of the translators at the end of the day.
I have something in that respect, because that basically means that if you take the German version, then it would impose stricter rules than if you take the English version, and in light of the recent decision by the European Court, that cannot be or shouldn't be. So what do you see there as the implications?
So the judgment you referred to was about a Spanish provision which was on this legitimate interest criterion, and the Spanish implementing law has basically imposed additional requirements on top of what that directive requires. I think this case is a little bit different because here the German provision basically just takes the literal translation of the directive in the German version. So they are not adding anything. They are relying exactly on what the directive says. So I don't know. It's speculation. It's speculation.
Okay. I thought one of the things I did think that in terms of the directive that it was only a floor on a ceiling, so that other obligations could be added, and indeed I believe in Italy, for example, personal data includes the data that companies sold or sold. But one thing that worries me about what you say about pre-trial review, the interpretation of what pre-trial review means in Germany, pre-trial disclosure means in Germany. I mean, we have an act of parliament which implemented the convention in 1975, and we made the same derogation under Article 23, and we regard pre-trial disclosure as being the exercise of disclosure in the proceedings. So, for example, if parties ask for specific documents which are to be used at trial, in other words, not pre-trial disclosure, it's not part of the disclosure exercise, but it's for documents to be used at trial in order to do what it says in 26D, then we do grant that. And it's surprising. Do you think it's not a surprising view that for the German courts to take the pre-trial disclosure means disclosure at all? Because on your interpretation, you'd never get any documents on the day, would you? You only get all evidence, which you wouldn't get any documents ever of any sort. I mean, that can't be what was intended by the derogation.
Unfortunately, I'm not able to comment on what was intended and whether this is complied by the German courts. But I mean, these reservations or these different interpretations are unfortunately not court interpretations yet. There's only very little case law, and there's, to my knowledge, no case law whatsoever in German courts on the interpretation of data protection law in these circumstances. So it's all raised by literature, by legal experts. And that's yet the problem, because you are faced with a practical question, can I do it or can't I do it? And you have to interpret it yourself. But this is why it's often recommended to go to your data protection authority and talk to them for your particular case and ask them what they think you should do, or present them with a solution. And then in most cases, to my experience, the German data protection authorities are very cooperative, and they will try to help you and come up with a good solution. There was an example. It wasn't really an eDiscovery request in a court proceeding, but you know, in the Siemens case, a request by US authorities to hand over all kinds of documents, and in the end, Siemens was able to come up with a solution together with the Data Protection Authority, which the Data Protection Authority accepted, kind of two-step approach to see, first of all, whether, you know, some documents, do they really contain personal data, then all the things we've discussed, anonymization, pseudonymization, filtering in the EU, so all kinds of additional safeguards, and the Data Protection Authority was very happy with it. Maybe just one side comment, all the recommendations both by the French Data Protection Authority and by the German Data Protection Authorities, they are very much in line with your Sedona Conference principles. So yeah, it's really, you take a risk these days, because there's no clear guidance. There's certain guidance, but only up to a certain amount.
Okay, as we're coming to a close, I have one last question for each panelist. What are your hopes and fears regarding the new draft regulation that was published yesterday, as far as the impact on cross-border eDiscovery? Will it make it easier? Will it make it harder?
Well, I think in one way it should make it easier, because if you have a centralized decision-making group that interprets things in a uniform manner, then doing the things that we talked about in the Sedona Conference principles should be done only once. In other words, you only have to make sure you're compliant once it was. It is very difficult for us in the United States to deal with all the different member state laws, including the variations like the Spanish interpretations and the German interpretations. And in France, you have to go to DPA, and there's all kinds of different nuances, even though they're all these data protection authorities are supposedly interpreting the same regulation. So that would be easier. What I was a little bit concerned about was come up with language that would essentially create a blocking statute, which would basically send the U.S. and the EU to opposite sides of the ring, because at that point we don't have cooperation and we're going to run into a lot of conflicts. So I was happy to see that that was not enacted, or something like that works its way back in, because
said in her press conference really comes to pass, and that is that the European Parliament and others that are now tasked with looking at this regulation will find a middle way forward that, to the extent possible, harmonizes the real practical concerns we have in this global age, given cloud computing, given social networking, given the trend toward collaborative use of technology, and will not take a dramatic position one way or the other. I think she did a nice job of navigating those competing currents and in removing that essentially EU blocking statute from the current version. My fear would be that we would regress and not progress, because after all, these are real jobs at stake throughout the world. These are people that need to earn a living to feed their families that we're talking about. These issues have a real impact, a significant direct impact, not talking about theory, not talking about interpretation of one academician over another, not talking about just a philosophical debate. There are real practical costs and risks, and I would hate to see us regress to a point where it would negatively impact international commerce and negatively impact the free flow of information for the benefit of EU citizens and for the benefit of US citizens, as well as the benefit of citizens throughout the world, let alone the impact that it might have on the ability of companies to spend their money on building the business rather than dealing with sanctions and dealing with litigation issues arising from this tension. My greatest my greatest hope really is aligned with what Amor said, a one-stop shop where you have hopefully one person that you know you're going to, and you have a common decision, a framework. And the greatest fear is that it won't remain balanced.
Yeah, I basically agree with what you said. If there had been this famous Article 42 in the draft regulation still, then yeah, something would have changed, because then you would, in all cases, have needed prior authorization by data protection authorities to transfer data for such requests. Now, with this provision being gone and only a recital being left, I think the situation is less clear. I think it's pretty much the same situation as under the current rules. And then the question only is, okay, it will be a regulation in the future, not a directive, but I mean, the basic principles remain the same. So you need to apply these rules on a concrete case. And then if you have a rule which says, okay, processing is justified if it's for a legitimate interest, and you have to balance it, while if you ask different people, they may come to different conclusions. So I still think, even if it's a regulation, there's still scope for different interpretations at national level, and it remains to be seen whether through the Article 29 Working Party and maybe Commission papers which clarify things, implementing measures, the scope of discretion can be reduced. But I mean, again, it takes time before Article 29 Working Party opinion is issued, and it will take time before implementing measures are issued. And I don't think they can cover in these papers every scenario. So I still think even in the future, there will remain some scope for different interpretation.
As you mentioned, there might be also sign from the Article 29, which will become the new subgroup eDiscovery in February, so works will start again about a new advice on eDiscovery, so it should be interesting to see what additional input the Article 29 Working Party shall recommend in this new text. And of course the setup conference which already had some interesting discussion between the working group and the setup conference group should have been going on with these discussions to come with a new document that would be maybe more practical and with some additional recommendation.
For me, it's definitely a step in the right direction. I do like the entire, the one-stop shop approach, which is a bit similar to drug approval procedures, where you have a sort of certainty that you apply to only one authority, and then that is your process. I think that's, from a practical standpoint, an improvement. But I do agree with Monica that it remains to be seen how this is interpreted in the end. Looking at the articles, it's not a whole lot that changes from our perspective in that sense. So there is, still room for interpretation, and it remains to be seen how that is filled out. So maybe
to add on something what you also said, I mean, this interpretation is also triggered by different traditional, historical, constitutional considerations in different member states. And also other laws, as you've mentioned, employment law, telecoms law. So again, these interpretations is not, everybody will not look at it with the same eyes. People have different perceptions on different notions, and this is an additional complication.
Yeah, I think we're all going to be singing the same song. My fear is that there will be resistance to this being in effect a regulation which puts a level playing field across the whole of the EU, assuming that no one opts out. The idea that the directive harmonised data protection law in the EU as it was intended to is a joke, as we all know. The problem will be if it's not regarded as something which not only replaces the directive because it effectively repeals it, but also as something which replaces all the individual state laws on data protection that were enacted to bring into effect the directive. And the other thing, just touching on the point of interpretation, I think the important thing to remember is that in theory, there should be no question of separate interpretation, because if a question of interpretation of an EU regulation arises, it should be referred to the Court in Luxembourg to decide. And I hope that very soon after this comes into effect, the Court in Luxembourg will at least get the chance to make decisions which will ensure that this is applied in the same manner in every EU country, without the possibility of differing interpretation, because otherwise it will have largely missed its point. From my own personal point of view, I have to say, I'm delighted that Article 42 was taken out, because it would have just increased my work burden, because I'd have had a lot more Hague Convention requests to deal with, and I'd have had the added problem probably about the DPA in our country being involved in some of those requests and appearing to object to orders being made. It would have made my life much more difficult, and I'm very glad that that's gone. It would have been horrendous, not only for international comedy, but I wouldn't be surprised if there are not people in the Parliament who would question that article has been taken out. So my general comment would be, let's hope that it is applied evenly with a common interpretation throughout the Union, and the European Court ensures that that happens as quickly as possible.
It's always marvellous being the last one after such a panel of esteemed speakers. I agree. I will make one point, and that is that I believe that there's a lot of data that is transferred out of the EU to the United States not apply, where the rules have not been applied. I believe that the new regulations